In the previous couple of videos, we've been looking at certainty of objects, and specifically we've had a little look at the distinction between powers, fixed trusts and discretionary trusts, and how those are dealt with respect to certainty of objects. And in this video, we're really going to dive into the various forms of uncertainty with respect to certainty of objects. So in an article by Emery in 1982, a division between various forms of uncertainty was made, and it was said there were 4 types of uncertainty with respect to certainty of objects. We have conceptual uncertainty, evidential uncertainty, ascertainability, and administrative workability. And this is going to be perhaps a slightly longer video than I would really like to make, but unfortunately, all of these concepts sort of have to be discussed, I think, in one video, just to make it easier for you. But in future, I'll try to keep those videos a little bit shorter. So the point was made in this article by Emery is that differing forms of uncertainty will or will not affect the validity of a trust in different circumstances. So the is or is not test applies to both discretionary trusts and powers. However, despite this test, which we talked about in my previous video, despite this test allowing there to be a more flexible pool of beneficiaries, there are some uncertainties which mean that the trust or power will be void. And that's really what we're going to be talking about now. So conceptual and evidential uncertainty are our first 2 types of uncertainty that I just mentioned a second ago. And uncertainty may be conceptual, so what is a young person, or evidential, who was an employee of a company at a certain date. In general, a trust in which there is conceptual uncertainty is more likely to fail than a trust in which there is evidential uncertainty. So the issue of conceptual uncertainty is the most fundamental in the validity of a trust or a power. So the situation that is caught by this form of uncertainty is where the meaning of the words used in the trust are unclear or vague. So words will be conceptually uncertain if the exact meaning of the definition used contains any linguistic or semantic uncertainty. If, in other words, it is impossible to say what the words in question actually mean. Obviously, if the terms used are unintelligible to the trustees and the court, the trust cannot be carried out. Often, there is conceptual uncertainty where vague phrases are used, for example, friends of the settler, or good customers, or pure-blooded Englishmen, or useful employees. In short, if it is found to be impossible to be certain of the concept, the trust will fail. So, what about a class of young persons, as I've used here? Is someone aged 25 a young person or not? This is a question that you could ask yourself. Is that uncertain? So a trust for young persons would be challenged on the basis of conceptual uncertainty, because who knows what is meant? What is the definition of a young person? We've also got evidential uncertainty, and so aside from the problem of interpreting the concepts used in the trust, which is conceptual uncertainty, it is possible that it is simply impossible to prove as a question of fact whether or not a beneficiary falls within a class. Therefore, evidential uncertainty refers not to the meaning of the words involved, but rather to the question of whether or not the claimant can prove that she falls within the class of beneficiaries. For example, a trust provision which entitled the holder of a season ticket to Chelsea Football Club in the season 2013 to 2014 to a distribution from the trust fund on presentation of a ticket is conceptually certain. That is conceptually certain because we know what it is meant by having been a season ticket holder in an identified season. However, for those season ticket holders who have lost their tickets, it would be impossible to prove that they are genuinely beneficiaries. Therefore, their own claims would fail for evidential uncertainty because they would be incapable of proving that they fall within the class of beneficiaries. But the trust fund itself could be valid because the definition of the class of beneficiaries is sufficiently clear. Where it is impossible to prove whether or not the potential beneficiaries succeed in falling within the category, this will not invalidate a trust or a power of appointment in most circumstances. And this appears to be consistent with good sense. There is no reason to invalidate the trust simply because someone who falls within a perfectly comprehensible trust provision is not able to produce the proof necessary to demonstrate to the trustees that she is indeed within the class of beneficiaries. Given the underlying policy motivation to validate trust wherever possible, that there are problems of evidence rather than concept, it would appear inappropriate to avoid the trust. So generally, a trust will not fail for evidential uncertainty, but it is likely to fail for conceptual uncertainty. So we got this case here, which is Rebaden's Deeds Trust, number 2 from 1973. Now, following from the decision in McFerrin Dalton, which we looked at in the previous video, which said that a discretionary trust would not fail if it was possible to say with certainty if a particular postulant was or was not a member of the class of beneficiaries. The matter was returned to the High Court for the is or is not test to be applied. And under the name of Rebaden, the matter reached the Court of Appeal some 12 years later after the testator's death. So this case is basically McFerrin Dalton number 2, in other words. So McFerrin Dalton went up to the House of Lords to decide what the test was for certainty in the case of discretionary trusts. And the House of Lords handed down its judgment in 1971. It held that a discretionary trust would not fail if it was possible to say with certainty whether a particular postulant was or was not a member of the class of beneficiaries, which is what we mentioned in the previous video. And then they went back to the High Court to apply the law set out by the House of Lords to the particular facts of the case. So under the name Rebaden here, the matter came before the Court of Appeal in 1973, so 12 years after the testator had died. The residuary beneficiaries were clearly not giving up without a fight. There was a lot of money involved, and they were highly motivated to get it overturned. And the court didn't like this, as seen by the judge in this case, and he said that I feel impelled to observe that the situation lacks attraction. The mere recital of the timetable of events is sufficient to disclose something that is less than creditable to the process of law, and something which could have been avoided. So the Court of Appeal was clearly in no mood to snatch victory for the residuary beneficiaries from the jaws of defeat, having collectively lost in the House of Lords. The Court of Appeal considered whether the terms relative and dependent were conceptually certain, and it held that both were capable of being defined with a sufficient degree of certainty. So anyway, the particular issue to be determined was whether the disputed terms relative and dependent were conceptually certain. This is really what we need to know from this particular case here with regards to certainty. So it was held that they were conceptually certain and therefore could be upheld. So the Court of Appeal unanimously agreed that the trust deed was valid. However, as many people did actually point out, the actual definition of a relative used in the High Court and approved in the Court of Appeal was descendants of a common ancestor. And this technically encompass everyone, as we are all descendants of a common ancestor if you go back far enough. So we are all relatives by that definition. So it was held that this trust would not fail for conceptual uncertainty, as it was possible to understand the concepts of relative and dependent and define those classes. And to continue what the judge was saying in this case, it was said that once it had been upheld that the terms were conceptually certain, they held that the trust would not fail for lack of evidence. It was held that the onus was on a potential beneficiary to provide any evidence required by the trustees. In the event that the evidence was not forthcoming, the trustees might presume that the person did not satisfy the test. So The judge here upheld the literal application of the is or is not test, but held that the burden of proof should be reversed so that it fell on the person claiming to fall within the class of beneficiaries and not on the trustees to prove that she is or is not within the class of objects. Consequently, the claimant would be required to prove that she fell within the classes of objects, and if she could not prove it, then she would be deemed not to fall within the class. Thus, the judge here upheld the literal meaning of the is or is not test, but changed who it was who was required to prove whether or not she fell within the class of objects. Many trusts would thus be validated because a lot of the certain uncertainty could be resolved in this way. But the judge here, Sachs, did not, however, intend that this reversal should validate all discretionary trusts. Rather, his lordship held that if the concept that defined the class was too vague, for example, on trust for nice people where it cannot be known what nice means, then it would still be found to be void. And he continued, as Mr. Weinlot, I'm not too sure how you say that name, but as Mr. Weinlot himself rightly observed, the court is never defeated by evidential uncertainty, and it is in my judgment clear that it is conceptual certainty to which reference was made when the is or is not a member of the class test was enunciated. So, if there is no evidence proving you fall within the class, the trust will not fail because the court will presume you do not fall within the class. Trust will not fail for evidential uncertainty, but will fail for conceptual uncertainty. And he continued, once the class of persons to be benefited is conceptually certain, it then becomes a question of fact to be determined on evidence whether any postulant has, on inquiry, been proved to be within it. If he is not so proved, then he is not in it. So that really wraps up what Sachs was really saying in this case, but the court also gave direction on how the trustees should approach the task of exercising their discretion in cases where there was a wide range of potential beneficiaries, such as ex-employees of a large company. So in cases where the class of beneficiaries is ex-employees of a large company, this is conceptually certain, so it will not fail, but how will trustees go about exercising their discretion when there is such a wide range of potential beneficiaries? And so Sachs continued, and he said that in McFerrin Dalton, Lord Wilberforce had said that the trustees should make such a survey of the range of objects or possible beneficiaries as will enable them to carry out their fiduciary duty. It was argued that this meant that the trustees had to carry out a complete survey of all possible beneficiaries. This requirement would, however, have made the is or is not test indistinguishable from the list test. So in such cases, the trustees cannot just wait for the postulants to come to him. Trustees are obliged to make a survey of the class to get a feel for who is potentially in the class when they exercise their discretion. It was argued by producing such a survey, it would have been similar to producing a list of beneficiaries so that the is or is not test became indistinguishable from the list test. In my judgment, the requirement of a survey, refers to something quite different to a need to provide a list of individuals or to provide a closely accurate enumeration of the numbers in the class. It relates to that width of the field from which beneficiaries may be drawn and which the trustees should have in mind so that they can adapt to it their methods of discretionary selection. So, however, here, Sachs said that the requirement of a survey is actually quite different from the list test. It just helps the trustees understand the breadth of potential beneficiaries to keep in mind when exercising their discretion. There are no directions as to how the trustees should complete the survey, but sending out an ad in the company press to make the potential beneficiaries come forward is one potential way of doing it. But they had to come up with some kind of survey. But as I understand it, having made the appropriate survey, it matters not that it is not complete or fails to yield a result enabling you to lay out a list or particulars of every single beneficiary. Having done the best they can, the trustees may proceed upon the basis similar to that adopted by the court, where all beneficiaries cannot be ascertained and distribute upon the footing that they have been. So this is not the same, as you can see here, as a requirement to make a list. Okay, so that is Baden's deed trust, and that is our discussion about conceptual and evidential uncertainty complete. We now need to talk about administrative unworkability. So another reason why the trust might fail is administrative unworkability. So if a trust is found to be administratively unworkable, then it will be invalid. So there may be a third case, as it says here, where the meaning of the words used is clear, but the definition of beneficiaries is so hopelessly wide as not to form anything like a class, so that the trust is administratively unworkable, or in Lord Eldon's words, one that cannot be executed. I hesitate to, as Lord Wilberforce says, I hesitate to give examples, for they may prejudice future cases, but perhaps all the residents of Greater London will serve. I do not think that a discretionary trust for relatives, even of a living person, falls within this category. So, even if the phrase is conceptually certain to identify a specific class of beneficiaries, the words may be too hopelessly wide, in other words, be administratively unworkable for the trust to be administered properly. So, for example, the residents of Greater London is conceptually certain, and evidentially it would not be too difficult to prove who the residents are, but the class is hopelessly wide and would fail for administrative unworkability. Another example would be, suppose for example that a fund of £10,000 is settled on trust to be distributed between all registered supporters of Chelsea Football Club, who are naturally red-haired and taller than 6 feet. So this concept is certain, and it will be possible for any postulant to prove that he falls within this category. However, if the trustees are two ordinary individuals, it would be a large task for them to administer a settlement among such a potentially large group of people. If, for example, the trust referred to all living people in England and Wales who are naturally red-haired and more than 6 feet tall, then that would, be a very similar sort of concept. That would also be administratively unworkable. Indeed, it would appear to be such a great task that it ought to be declared invalid, and that's what they would do. So let's look at an example here. So we got Exparte West Yorkshire Metropolitan County Council, and in this case a local authority placed some discretionary funding which they would otherwise not be entitled to into a trust with the purpose of benefiting the inhabitants of the county of West Yorkshire by providing financial assistance for the relief of poverty, to support youth and community groups, and to inform interested and influential persons of the consequences of the abolition of metropolitan councils. So here the beneficiaries were not conceptually uncertain, but the trust failed for administrative unworkability. A trust which would have had the effect of including within its class 2.5 million people in West Yorkshire was held to be administratively unworkable. It was held the objective contained within the trust, coupled with such a broad geographic region and large body of beneficiaries, would be administratively unworkable, and the power was consequently void. So that gives us a very quick and clear case about how administrative unworkability has led to the invalidity of the trust in practice. So we've also got the case of gifts and trust for the benefit of a community, and although gifts to a wide range of people can fail for administrative unworkability, a gift to the community will be validated actually as a good trust. Okay, so we've got the case here of Smith, and in this case, a testamentary gift to my country, England, own use and benefit absolutely, was upheld as a charitable gift. So because it was for the benefit of the community, it was upheld as a charitable gift. Okay. The other particular case we have is Harding, so Gibson Harding from 2007. And it was said that it is my wish that everything I possess to be taken over by the Diocese of Westminster to hold in trust for the black community of Hackney, Haringey, Islington and Tower Hamlet. So this express trust for the black community of these areas was upheld as a charitable gift too. And this raised two main issues. The first was that the gift was to a community defined by race, and this in turn raised the question of how the black community was to be defined, and that charities for the benefit of people of a particular race are actually forbidden by Section 34 of the Race Relations Act 1976. Okay? And the same section provides that any charitable instrument so expressed should be construed as if there was no reference to race. Accordingly, if it were a charitable gift, it would take effect as being for the benefit of the communities of these particular areas. So therefore, the reference to race was actually struck out, and the gift to the black community was upheld as a gift to just the communities of the said areas. The second issue was whether the trust was void for administrative unworkability, and the court held that they would not overturn a gift for the benefit of a community if it was possible to construe the donor's or testator's intention as charitable, and that a gift to community would be construed as charitable. So, although it looked administratively unworkable, the court said that they would not overturn a gift to the community if it is the testator's intention that the gift was provided for charitable purposes. And in District Auditor case, which we looked at a few slides ago, the trust was for 4 purposes, 3 of which could be charitable. The fourth power, to inform all interested and or influential persons or bodies of the consequences of the proposed abolition of the West Yorkshire Metropolitan County Council and other Metropolitan County Councils, was not charitable. The trust could not therefore take effect or be construed as a charitable trust. So because the trust in this case included a non-charitable purpose, the trust could not take effect or be construed as a charitable trust. Hence why the outcome was different in this case. If all the objectives in the case had been charitable, it would likely have been rescued as a charitable trust, and therefore it would not have failed for administrative unworkability. So as a general rule, gifts to the community are fine, and they are not administratively unworkable as they are charitable. The problem comes when it is a non-charitable gift, and the court cannot rescue these trusts. Okay, I'm going to end this here, and that was really the end of certainty of objects and our 3 main certainties now. In the next video, I'm going to move on to talk about a potential 4th certainty, where we can talk about conditions subsequent and conditions precedent. But if you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to subscribe to my channel and like this video. Thank you very much for watching.